afternoon, everybody. My name is Jan Marinus Wiersma. I will be the moderator of this afternoon's event, organized by the Montesquieu Institute and the Institute of International Relations. But before I introduce the main guest, our main speaker, I would like to ask the director of the Office of the European Parliament here in The Hague, who is our host today, to say a few words on that. Please.
Thank you, Jan Marinus. A warm welcome to you all here in the House of Europe, which we exploit together with the European Commission here. My name is Egbert Myjer. A warm welcome today also to the keynote speaker, Professor Egbert Myjer, former judge of the European Court, and naturally also to Jan Marinus, former member of the European Parliament. A warm thank you for the Montesquieu Institute in Klingendael for organizing this discussion and bringing us all together. Today's topic is why the European Court of Human Rights is vital for rule of law monitoring in Europe. I think it will be a very interesting discussion also because on first sight it seems we have two competing international organizations claiming to do the same. On one hand, you have the European Convention on European Rights with the European Court in Strasbourg. On the other hand, you have, of course, the Charter of Fundamental Rights of the European Union enshrined in the Lisbon Treaty. Luckily, we have also this famous Article 6 of the EU Treaty, which aims to unite the two and even stipulates that the European Union will become a signatory of the European Convention. And if I'm not mistaken, the roadmap is that to date the EU is waiting for an opinion of the court in Luxembourg. And so within 1 year, the 47 parties can sign. But okay, I've spoken enough, and I would like to give the floor back to Jan Marinus.
Thank you very much for your hospitality. This is a conference room we often use because it's such a nice place to meet, and it's also very close to everything that is important here in The Hague, like the Parliament and all the government buildings. Thanks again. So today, this afternoon, we have a special guest, Professor Egbert Myjer, who now works for the University of Amsterdam, but in the past, Free University, sorry, no, but also in Amsterdam. Of course, the main reason why we invited you to speak today is because you were a judge at the Human Rights Court of the Council of Europe in Strasbourg. And today, we will use the opportunity to listen to you on the role of the Council of Europe, especially of this court, when it comes to upholding the rule of law, defending human rights in the member states of the Council of Europe and all member states of the European Union, also member states of the Council of Europe. This debate, we're organizing a series of debates linked to the whole debate about rule of law in relation to enlargement of the EU, in relation to new member states like Romania and Bulgaria, in relation to the problems we had with the rule of law. At least some people think there are problems with the rule of law in Hungary, problems with Italy, the problems with corruption in countries like Greece. So there's a series of discussions. Last year we had one about corruption in the Balkans and the problem with organized crime. This afternoon earlier we had a debate with experts on what kind of mechanism the EU could develop to better protect the quality of the rule of law in the member states. And you probably know about an initiative taken by 4 ministers of foreign affairs, including Frans Timmermans, a letter sent to the President of the European Commission asking for the establishment of a mechanism to better monitor and assess the quality of the rule of law in the member states. And I think it's very important that you have this debate, and we're still at the beginning, because it's still unclear what kind of mechanism we then should put in place, how can it work, and what pitfalls to avoid, mistakes made in the past, how to organize also the political support for such a mechanism, because that's always a problem, the political support of member states. And it's of course very important then to look at the example we have already, a very important European organization that has been dealing with this issue for tens and tens of years already, including of course a human rights court that has a legal authority to deal with cases of human rights violation. So we are very pleased that in this series of debates we now have the possibility to listen to Professor Egbert Myjer, former judge in Strasbourg. And please, you take the floor now, and afterwards, of course, there will be ample opportunity for you to discuss with Professor Myjer his speech and other questions you might have. Please.
Thank you, Chair. Ladies and gentlemen, first of all, let me explain, but it's a little bit complicated. I used to be a professor at the Amsterdam Free University before I was appointed a judge in Strasbourg. When I was appointed a judge in Strasbourg, I got a successor immediately, Martin Kuijer, who's sitting there. He's the only one who's smiling now. I got extraordinary leave from my function as professor. And when I returned from Strasbourg, then it turned out that I was so old that I was entitled to get AOW, and that makes it impossible to continue your professorship. So I'm a real emeritus now. Still, that doesn't matter. I'm not talking about emerity, I'm only talking about why the European Court of Human Rights is vital for the rule of law monitoring in Europe, because that was what I was invited to do. And I'd like to give you an example. It's an extraordinary example, but still, I'd like to talk a little bit about that one case and then continue on a more theoretical part. On the 13th of December last year, the European Court of Human Rights delivered a judgment in the case El Masri versus the former Yugoslav Republic of Macedonia. And this El Masri case concerned secret or extraordinary, that's the third time I used that word, renditions. When I look at the judgment in that case, the facts, which read like a unrealistic B-movie script, the facts were in the judgment described as follows. There was a German-born man from Lebanese descent, El Masri, who on the 31st of December 2003 boarded a bus in Germany towards Skopje. He wanted to visit Skopje in Macedonia in order to take a short vacation and some time off from a stressful home environment. What happened is that at a certain moment the bus arrived at the Serbian-Macedonian border, and then a suspicion arose as to the validity of the recently issued German passport of Mr. El Masri. His passports were checked, he was questioned, and then he was taken to a hotel in Skopje. Later on, I'll explain how the court knows all about this. He was taken to a hotel in Skopje, to a room on the top floor of the hotel. And in fact, he was detained, watched by a team of 9 men who changed shift every 6 hours. 3 of them were with him at all times, even when he was sleeping. He was interrogated repeatedly throughout the course of his detention, and he was interrogated in English. He asked to be able to contact the German embassy, but that was refused. After 7 days of confinement, he was offered a deal that he would be sent back to Germany in return for a confession that he was a member of Al-Qaeda. He then commenced a hunger strike to protest against his continued unlawful detention. He did not eat for the remaining 10 days of his detention in Macedonia. And after a week, he was told that he would soon be transferred by air back to Germany. And on the 31st of January, it's still a B-movie script, but it's the true facts. He was filmed by a video camera and instructed to say that he had been treated well, that he had not been harmed in any way, and that he would shortly be flown back to Germany. He was then handcuffed and blindfolded, put in a car and taken to Skopje airport. Upon arrival there, he was initially placed in a chair where he sat for 1.5 hours. He was told that he would be taken into a room for medical examination before being transferred to Germany. Then 2 men violently pulled his arms back. He was beaten severely. His clothes were sliced from his body with scissors or a knife. His underwear was forcibly removed. He was thrown on the floor. His hands were pulled back. A boot was placed on his back. He then felt a firm object being forced into his anus. And what then happened is that he gets some injections, and he more or less falls asleep. He then sees at a certain moment that he is surrounded by 8 men, 7 or 8 men, dressed in black and wearing black ski masks. He is then dressed in a dark blue short-sleeved tracksuit, a bag placed over his head, a belt put on him, chains attached to his wrists and to his ankles. And he finally finds himself in a country which feels differently from the country where he came from. And later on it turns out that he is in Afghanistan. In Afghanistan, he has been driven for 10 minutes to a place which we now know is a CIA-run facility, which has been identified as the Salt Pit, a brick factory north of the Kabul business district, used by CIA for detention and interrogation. He is then interrogated 3 or 4 occasions, each time by the same man, who spoke Arabic with a South Lebanese accent, and each time at night. And the interrogations were accompanied by threats, insults, pushing and shouting. In March, he starts a hunger strike, and as a consequence of that hunger strike, his health deteriorated at a daily basis. The hunger strike is forcibly stopped. He is then force-feeded, becomes extremely ill, and at a certain moment he is visited by a German speaker who identifies himself as Sam. And that Sam visited the applicant, as it's called in Strasbourg, 3 times prior to his release. He then begins a second hunger strike, and in the end of May, blindfolded and handcuffed, he is led out of his cell, locked in what seemed to be a shipping container, until he heard the sound of an aircraft arriving. And to put a long story short, he then finds himself in Albania, near the border of Macedonia. He is there released, and he is told that he should walk in a certain direction. He's then stopped by 3 guards who say, "Do you have a passport? Why don't you have a visa for Albania in your passport? We will transport you back to Germany." He is then transported back to Germany, and there all kinds of investigations took place. And in the end, Mr. El-Masri also applies to the Strasbourg court, and applies to the Strasbourg court, files a complaint that he was tortured, that he was treated in violation of Article 3, that is torture, 5, illegal detention, 8, privacy, 13, no possibility of ever bringing his case to any judge. And this El-Masri case is one of the best documented cases on secret renditions which took place in the aftermath of 9/11. And I must admit that El-Masri was sent back. By doing so, the CIA must have been aware that publicity might happen. And I'm pretty sure that other secret services, or in other countries where someone had been mistakenly abducted, they would never let him go and would rather have a person like that disappear. That didn't happen to El-Masri. He was sent back when it was found out that apparently he had nothing to do, as far as we know, with Al-Qaeda. And again, It is now one of the best documented cases on secret renditions which took place in the aftermath of 9/11. And just to remind you, I guess that a lot of you are keen fans of Borgen TV series. In the first year of Borgen, one of the episodes was about secret renditions in Greenland. It is a topic which indeed caused a lot of uproar in several European countries. It's one of the best documented cases again. I can tell you it is not the only case on secret renditions. There are still other cases pending before the Strasbourg court. The case of El-Masri was earlier investigated, and that's exactly the reason why I'm starting with the El-Masri case, by other monitoring mechanisms. First of all, by the Swiss senator and member of the Parliamentary Assembly of the Council of Europe, Dick Marty. He was asked by the President of the Parliamentary Assembly of the Council of Europe to investigate allegations of extraordinary renditions in Europe. And he did so. He wrote 2 reports in 2006 and 2007. And those with long memories will remember that the member state mentioned in the Marty reports all heavily denied that any extraordinary rendition had taken place. Marty was, in all these countries, described as a man with too much fantasy, who had written his own fairy tale without taking care of any real facts. When you try to Google on the name of Marty and on his report, you can still find reactions of several countries in Europe who say, well, this is the biggest nonsense we've ever heard of. This is completely stupid. How does he dare to do things like that? On the 21st of November 2005, the Secretary General of the Council of Europe invoked a procedure under the Convention for Human Rights with regards also to reports of European collusion in secret rendition flights. Member states were required to provide a report on the controls provided in their own internal law. And I can assure you that that official request of the Secretary General of the Council of Europe didn't have any results on indeed secret renditions. The Macedonian government in 2006 informed the Secretary General of the following, and I'm going to read that. The Ministry of Internal Affairs of the Republic of Macedonia informs that, based on police records on entry and exit at state border of the Republic of Macedonia, Mr. Khaled El-Masri arrived by bus at that border crossing from the State Union of Serbia and Montenegro on the 31st of December at 4 p.m., presenting a German passport. Suspecting possession of a forged travel document, the competent police officers checked the document and interviewed Mr. Khaled El-Masri at the border crossing. And a check in the Interpol records was also carried out, which showed that no international arrest warrant had been issued for Mr. El-Masri. Mr. El-Masri was allowed to enter the Republic of Macedonia on the 31st of December at 8:57 p.m. and according to the police records, Mr. El-Masri left the Republic of Macedonia on the 23rd of January at the Blaze border crossing to the State Union of Serbia and Montenegro. That's it. The official document presented by the Macedonian government at this request of the Secretary General of the Council of Europe, well, he arrived that date. That happened, and he went off that other date, 23rd of January, indeed, the date that he was taken back by the CIA flight to Afghanistan. That is all. What is written back? In January 2006, also the European Parliament set up a temporary committee on the extraordinary rendition and appointed Mr. Fava as rapporteur with a mandate to investigate the alleged existence of CIA prisons in Europe. And the Fava inquiry held 130 meetings and sent delegations to Macedonia, United States, Germany, United Kingdom, Romania, Poland and Portugal. It identified at least 1,240 flights operated by the CIA in European airspace between the end of 2001 and 2005. During the visit of the Flava Committee, they also met with high-ranking officials in Macedonia. And in July 2006, the European Parliament adopted a resolution on the alleged use of European countries by the CIA for the transportation and legal detention of prisoners. And it then adopted a resolution, indeed, to say, well, this can't be true. We condemned that this happened. We also condemned the fact that the German national Al-Masri was held illegally in Afghanistan for more than 4 months. And after that, another report was also adopted by the European Parliament. The court, in the Al-Masri case, unanimously concluded that Mr. Al-Masri was tortured, was indeed that the torture was not investigated in a proper way, that Macedonia was also responsible for his transfer into the custody of the United States authorities, that the detention in the hotel was illegal, that the Macedonian government is responsible for Mr. Al-Masri's subsequent captivity in Afghanistan, and also for violation of his family rights, privacy rights, and also that he didn't have the possibility to go to any judge to see if his detention or whatever was legal. The Macedonian government was ordered to pay Mr. Al-Masri €60,000. That is the story of Al-Masri. And why do I pay so much attention for the Al-Masri case? Just to make it clear that when, for political reasons, member states do not wish to publicly react to certain allegations that fundamental rights are not upheld, indeed, international parliamentarians or national parliamentarians may exercise some pressure or even do fact-finding and naming and shaming, but in the end, when even the national courts are approached in vain, it's only an independent international court that has the possibility to give a final and binding judgment. That is, in fact, the whole answer also for the question I was asked to talk about: why is the European Court of Human Rights vital for the rule of law monitoring in Europe? It's precisely because of this, because it's an independent judicial organ. When the European Court renders a judgment, that is it. And even countries, the member states, should treat a judgment differently from a resolution from parliamentarians. And we have seen in the Al-Masri case that both the resolutions of the Parliamentary Assembly of the Council of Europe and the resolutions of the European Parliament did not have any, as far as we can see in public, legal effect. But since there is now the Al-Masri case judgment, something should be done. The Al-Masri judgment is published. It is now up to the Committee of Ministers of the Council of Europe, under the provisions of the European Convention of Human Rights, to see that the Macedonian government indeed does what it should do, and that the judgment is executed. And what is being said in the Al-Masri case is also undoubtedly of importance to other pending cases on secret renditions. One may wonder, why could the European Court be so sure? But I must say, well, also the Marty report made it very clear this had happened. And also the Fava report made it clear something very wrong had happened with Mr. Al-Masri. Why is the European Court so sure? For those who are really interested, have a look at the judgment which is published on the website of the European Court. If those who are interested want to know what website, I can give it to them. The court was luckily also confronted with the fact that one of the politicians in Macedonia, who at the time of Al-Masri was in power, later on gave a written statement, and in that written statement that former Minister of Interior and afterwards even the Prime Minister, he confirmed that the Macedonian law enforcement authorities, acting upon a valid international warrant issued by the US authorities, had detained Mr. Al-Masri, kept him incommunicado, and under the constant supervision of the State Intelligence Service of Macedonia, and he had later been handed over in custody of a CIA rendition team at Skopje Airport and had been flown out of the respondent state on the CIA-operated aircraft. So I must say, the court was really helped by a written statement by a former Prime Minister saying, well, indeed, it's all true. But apart from that, if you look at the evidence, even presented in the Marty report, and Marty himself has stated that when he presented facts, he had at least checked them twice at the two independent sources. Then already you see that the whole pattern, which has finally been laid down in the judgment of the court, was also laid down in the Marty report. And although I don't have the time to do it, I just want, for those who are fond of legal reasoning, I want to read what the court said about that Prime Minister. It said the following. In principle, I'm now quoting the court's judgment, in principle, the court will treat with caution, it's a beautiful statement, with caution, statements given by government ministers or other high officials. Now, I have to say hello to my dear friend Roland Bucker, who is the agent of the Netherlands government before the Strasbourg court. I'm going to read it again. In principle, the court will treat with caution statements given by government ministers or other high officials. That doesn't apply to Roland. Since they will tend to be in favor of the government that they represent or represented. However, it also considers that statements from high-ranking officials, even former ministers and officials, who have played a central role in the dispute in question, are of particular evidentiary value when they acknowledge facts or conduct that place the authorities in an unfavorable light. They may then be construed as a form of admission. That's a beautiful statement. So, indeed, if the former Prime Minister says things like this must be true, especially since it places his own government in an unfavorable light. Again, the Al-Masri case, that's almost the end I'm going to say about the Al-Masri case, shows in a way why it is so important also to have an independent court, because governments can deny, like they did in the Marty report, like they did in the Fava report, what has happened, but when the government denies it the same way before the European Court of Human Rights, then indeed in a judgment you can read, well, these are the facts, and dear government, you are lying as hell. And it's only a European court which, in diplomatic terms, can say things like that. I'm totally aware that the Al-Masri case is exceptional and, again, extraordinary. Still, I can give many examples where the European Court has established that in a member state serious violations of fundamental rights took place, and where neither at the national judicial level nor at the national political level, Parliament included, any alarm bell ever rang. And in many cases, it was only the national branches of NGOs, non-governmental organizations, which asked in vain for attention. Now, time for more general information. The Council of Europe, and I'm talking about indeed the Council of Europe because the European Court of Human Rights is a body within the setting of the Council of Europe. The Council of Europe, which dates from 1949, is the guardian of human rights, democracy and the rule of law in Europe. It occupies a unique place on the international political stage and is the oldest international organization dedicated to fostering cooperation in Europe. It does this through the protection and promotion of human rights, democracy and the rule of law. It includes 47 member states, 28 of which are also members of the European Union. The Council of Europe promotes human rights through international conventions. The most important and well-known Council of Europe convention is the European Convention on Human Rights. All Council of Europe member states have signed up to that convention. To ensure the observance of the engagements undertaken by the state parties, a European Court of Human Rights was established. The state parties have accepted to abide by the final judgments of the European Court in any case to which they are parties. All member states are required to respect their obligations under the organization's statute, the European Convention on Human Rights, and other conventions to which they are parties, as well as to observe a series of principles, rules, standards and values which have been elaborated since 1949 with regard to democratic pluralism, human rights and the rule of law. The Council of Europe itself also monitors members' progress in human rights areas and makes recommendations through independent expert monitoring bodies. Possible sanctions for non-compliance with obligations and commitments freely entered into vary. As far as the Parliamentary Assembly of the Council of Europe is concerned, its ultimate sanction is the suspension of a national delegation from Parliamentary Assembly proceedings. And if a breach of an obligation is considered very serious and appropriate corrective sanctions are not forthcoming, the Committee of Ministers of the Council of Europe can commence a procedure which may ultimately lead to the suspension of the Council of Europe. I ask the organizers to give to all of you this leaflet, which is a leaflet with the organigram of the Council of Europe. And if you have a look at it, you can see that there are several bodies which indeed do a kind of monitoring. You have the Council of Europe as a whole, which is with the Secretary General, who has certain powers of inquiry. And in the Al-Masri case, I indicated to you that he used these powers of inquiry, for instance, to ask the Macedonian government to clear up what had happened. I also read you the answer, which was, we now know, a pure lie. You have the Parliamentary Assembly. And the Parliamentary Assembly, that is the Parliament of the Council of Europe, consisting of parliamentarians who are also parliamentarians at the national level. The Parliamentary Assembly itself has a monitoring function, among other cases. And the Parliamentary Assembly carries out many investigations. It does quite a lot of monitoring. The Martin report is a clear example of the way the Parliamentary Assembly does this monitoring. That ends up with a report. That report is then discussed within the in the Parliamentary Assembly. It will end in a resolution. That resolution will be sent to the Committee of Ministers. By the way, the Committee of Ministers, in practice, are the ambassadors of the 47 states who are member states of the Council of Europe. Every now and then, once a year, also real ministers will come, but normally it's the ambassadors who form the Committee of Ministers. Within the Council of Europe, there are several bodies which are all laid down in separate conventions which do monitoring. I leave out the European Court because I'm going to talk about it later. But after the European Court, I think the most successful one is the European Committee for the prevention of torture. You can see it at the left of the organigram at the bottom. That is, next to the court, I think the most successful monitoring body within the Council of Europe. The CPT has the right and possibility to go to all detention facilities in all member states. They have the right to have access, have a look there, and carry out investigations into what is happening in all these places where people are deprived of their liberty. In the old days, when CPT was founded, people said that CPT was even subsidized by the combined European paint factories. Because what happened is that when a committee of the CPT would come to prisons, they would tell them 1 week in advance that they would come. It would always smell after fresh paint. That was fantastic. Although, no, I shouldn't tell you the story. The first time the CPT ever came to the Netherlands, they also came, the story tells, at Almelo prison. And Almelo, for those who are not that familiar with the whole map of the Netherlands, Almelo is somewhere in the east, and they knocked. Well, no, there was a ring bell. They rang the bell and said, "Hello, we are the CPT. We have the right to enter." And the guard said, "Hello, we are the CPT. We have the right to enter and have a look." Well, everybody can say that. Would you please call the director of the prison and tell them that the CPT is there? Everybody can tell that. I won't do that. And well, in the end, they managed to get in contact with the Ministry of Justice in The Hague and the Ministry of Justice or Foreign Affairs. One of the two, I think, Ministry of Justice. Yes, Martin said yes. And finally, they were allowed in Almelo, but they couldn't believe that indeed this could happen. But it's a fantastic organization, and they draw up a report after each visit. And if you have questions on that, although we are talking about the European Court, ask Martin. He knows all about it, and it's really great, that monitoring mechanism. And it has a fantastic impact because they make a report. That report is confidential, but if a country refuses to publish it, then the country apparently has something to hide. So in the end, all countries will publish it, and well, there you can really find the what happens in prisons, and they are not critical. And I can assure you that we used the reports of the CPT as fact-finding for our own judgments as the European Court when there were complaints about detention facilities. If people would say, yes, we were in that and that prison, and we would have at our disposal a report of the CPT describing what the CPT had seen in that particular prison, then it was almost a blind violation if the CPT would have seen that indeed a lot had to be done. So CPT is a very successful monitoring mechanism, totally independent, and not only totally independent, also consisting of high-level professionals, and nobody normally ever dares to say that what the CPT has laid down is completely nonsense. So that in itself is, I must admit, a fantastic, really fantastic monitoring mechanism, not only as far as places are concerned where people are detained, deprived of their liberty, be it migrants waiting for expulsion, be it detainees, be it psychiatric patients who against their will are held in a psychiatric hospital. Then you have in the Council of Europe the Commission of Human Rights, which is an independent body who more generally describes whatever he wants to describe. And I must say, it depends on the person who is the Human Rights Commissioner. It used to be Thomas Hammelburg, it's a Scandinavian who was a very prestigious Human Rights Commissioner and who had a lot of very wise comments. It's now someone from Latvia, I don't know. I haven't seen his first report, so I can't say how he's doing it. Then you have other bodies which also do a part of monitoring. There is a group of states against corruption. It's not even indicated here. The GRECO. There is a group of experts on action against trafficking in human beings. It's also there. All right. GRECO. All right. There is the European Committee of Social Rights. There's an advisory committee on the framework for protection of national minorities, and there is also a framework for minority languages. All kind of bodies which indeed make a kind of monitoring in their field. The Committee of Ministers itself has also created a thematic monitoring procedure, and it's not without interest to quote from an article which I read when preparing this presentation, where it says the origin of the idea that the Committee of Ministers of the Council of Europe undertake monitoring can probably be traced back to a couple of statements made by the then Dutch Prime Minister Ruud Lubbers and seconded by the Norwegian Prime Minister Harlem Brundtland at the Council of Europe's first summit of heads of state and governments held in Vienna in '93. That is interesting if you realize that now, this very day, there was a discussion on the initiative, among others, by Frans Timmermans on some monitoring in the European Union. Apparently, also, there was once this initiative within the Council of Europe that the Committee of Ministers itself should also set up a monitoring procedure. However, the thematic monitoring was suspended already in 2006, and that monitoring didn't have the success I think it was expected, because that monitoring all took place in secrecy. It was all only within the Council of Ministers. It wouldn't be published. Only the general themes which were monitored were discussed, but the reports, the underlying reports, were never being made public. My friend Andrew Remsevsky, who wrote about an interesting article about in the Baltic Yearbook of International Law 2002, says the Council of Europe and its member states must be vigilant to ensure that so-called political monitoring, be it by the Committee of Ministers, the Parliamentary Assembly or others, does not provide an excuse to tamper with what the Committee of Wise Persons, that is a special committee set up at that time, called monitoring par excellence, namely the monitoring carried out by the European Court of Human Rights. There is a fundamental distinction, that is an important quote, that's why I'm reading it. There is a fundamental distinction between so-called political monitoring linked to commitments and generally statutory obligations undertaken by states, and legally binding instruments which possess their own, preferably independent control mechanisms, which ought not to be tainted, if at all possible, with political considerations. What he says is, it's good that there is this general political monitoring, but apart from general political monitoring, there are these conventions with legally binding rights, and you should have an independent body which is not tainted by any political taint, any political paint even, and you should have that independent body to deal with indeed the rights laid down in these conventions. Monitoring par excellence, that is the way the wise persons described the way the European Court of Human Rights works. And who am I to challenge that fantastic word monitoring par excellence by the European Court. A few words about the European Court itself. It was set up, as I said, in the European Convention on Human Rights, a convention which was signed in 1950, entered into force in 1953. The special thing in this European Convention is that the countries indeed promised that they would respect human rights. Article 1 of the Convention says, we shall secure to everyone within our jurisdiction the rights and freedoms defined in this Convention, and to ensure the observance of the engagements undertaken by the parties. There was this court, and the European Court has the jurisdiction to have a look at all cases, not only the application but also the interpretation of the Convention. And finally, the parties have promised that they would abide by the final judgment of the court in any case to which they are parties. Last year, more than 65,000 people filed an application with the European Court of Human Rights. 65,000 applications. Practice learns us that about 95, even more, % of these cases will be declared inadmissible. Inadmissible for different reasons. One of the main reasons being that first, the case should be dealt with at the national level, at the highest national level, and the court normally will accept at least the way national courts have looked at the facts or have applied the national law, unless what is done is clearly arbitrary. So the court itself says it very clearly, we are no fourth instance, not after the national court, Court of Appeal, Supreme Court, the last instance. No, we accept what national courts have done, unless it is contrary to human rights or unless it's clearly arbitrary. So 65,000 people applied, but what also happened is at least 1,600 judgments were delivered last year by the court. One of these judgments being the judgment in Al-Masri. So these were judgments, and not all judgments were judgments where the court has found a violation. It is well possible that the court says, well, after having looked at all the facts, it is no violation. But I think it is safe to say that at least in 1,000 of these cases, some violation has been found of one of the provisions in the European Convention. That is quite a lot. And not all cases are of the same importance as Al-Masri. Al-Masri is of extreme importance. And there are, among these 1,600 cases, about 25 cases which are dealt with by the so-called Grand Chamber of the Court. And these are especially cases where 17 judges have had a look at the case. And these are the most important cases concerning the interpretation. And there you can see, in a case like Al-Masri, but also in all kinds of other cases which are dealt with by the Grand Chamber, then indeed the court gives not only a detailed analysis of what might have happened, but also indicates what should be done in order to prevent things happening again. The convention system is a success story. What is very interesting is, and that again is of importance for all those who are talking about monitoring procedures, what is interesting is that the original idea of so-called interstate complaints did not work out. I think that in the whole convention history, less than 20 cases were interstate cases. And we are talking about hundreds and thousands of individual complaints at the same time. And the original idea was, the main thing is, the one state complains about the other interstate cases, and there's also the possibility for individual complaints. But apparently, states rather use other ways to reach their rule of law goals, like diplomatic negotiations, than via the publicity of an interstate complaint. When you see the statistics of last year, all the cases of last year were individual complaint. The result of so many cases is there are insufficient means to deal with all of them. There is a backlog. However, the backlog is decreasing and decreasing thanks to certain procedures, which have now been used, especially since last year. The European judges in the European Court are independent and impartial. They will judge on the merits of the case without political considerations. That is not always accepted by the member states. They do not always like the way the European Court rules, but I can assure you, if you have a judgment of 17 judges, the Grand Chamber, who are all elected, and the election, well, that's another story, elected after their national governments have indicated he might or she might be one of the candidates. When you have people, 17 judges, almost unanimously giving a judgment, then indeed something has been wrong when they find a violation. That can only happen the way the court does it, via a public hearing, via a judgment where you lay down all the facts and where you analyze indeed whether there has been a violation or not, and knowing indeed that there is this provision, Article 46 of the Convention, saying that a national country should abide with the final judgment of the court. Fact-finding is not always easy. It's easy in cases where people do not differ about what happened, but only differ about the merits, the legal merits. But sometimes fact-finding is very difficult, especially in cases where governments do not want to admit that something went wrong, like in Al-Masri, like especially in cases concerning torture or taking the life of somebody. A judgment finding a violation is often considered as a shame by national authorities. However, my experience is mostly it is not seen as a shame by other countries. When I was still working in the Netherlands, before I was elected in the court, I also wrote comments on judgments of the European Court. And when the Netherlands were found in violation, I would always check with a Belgian friend. Did you also read that judgment against the Netherlands? Are they stupid? And he would say, of course not. You Dutch are stupid. It sometimes takes an external auditor to tell you what should happen. That is also in management. And the European Court is not only a monitoring body, it's also a kind of external auditor telling national authorities, here you were wrong. And as I said, it's often so that national authorities first start to react by saying, well, this is completely nonsense, and after a while they accept, yes, maybe they are right. And a lot of these judgments, which once were considered by national authorities as completely stupid, are now considered to be the acquis of, and the acquis meaning it's the body of the protection mechanism in Strasbourg. And the same acquis is also now at the basis of the Charter of Human Rights of the EU, because when the Lisbon Treaty was adopted, it was also said that the minimum level was the European Convention on Human Rights combined with the existing case law, the acquis of the European Convention on Human Rights. the EU politicians themselves have accepted that the acquis of the European Court, the jurisprudence of the European Court, lays at the basis of the protection also within the EU. Challenges are future, that's another story. You heard that one of the things is that EU might also become a member of, also a party to the convention. Roland Bukker has written a most beautiful story that in the Nederlands Juristenblad, saying that it has to do with hedgehogs a little bit. The European Court of Human Rights and the Court of Justice in Luxembourg.
And all egels.
Egels. Yeah. It has to do with egels, hedgehogs. They love each other, but they are a little bit afraid not to hurt each other when they are circling around each other. Again, why, and that's my last word now before we enter into the discussion, why is the European Court vital? I think it's clearly shown in the Al-Masri case. There's a fundamental distinction between so-called political monitoring and the monitoring via legally binding instruments that possess their own, if possible, independent control mechanism. And the most independent control mechanism remains the independent international court. And that's the big fun of being a judge. Thank you.
Thank you very much, Professor Myjer, for a very interesting overview of the work of the Council of Europe and especially the Court of Human Rights, and also using, I think, an example, the Al-Masri case that makes very clear what the role of your court, the court you are a member of, can be, and what the problems are when politicians have to deal with cases like the Al-Masri case or the renditions more in general. I was a member of this committee in the European Parliament, the special committee. We call it the Committee for the CIA Flights. And the problem is that we know there were 1,300 flights, but we were never able to prove that national governments of EU countries knew about these planes landing at their airports and then taking off again. We were never able to prove it. That was a big problem. And of course then the member states said, is outside of their competence. It was also a problem. The European Parliament was not seen as competent by the member states to deal with the issue of the rendition. So in the end we had this report by FAVA, but there was never a reaction of the Council of Ministers. And we invited, I also remember, several times Mr. Solana, who was then the High Representative, to the Parliament to explain the position of the Council, and he always said, this is outside my competence. This is outside the competence of the European Union. So I think it makes clear what you said, that you need an independent mechanism to deal with issues like this. Human rights, but also more in general, I think, questions related to the rule of law. And that you have this gliding scale from the independent court to the assemblies, who are much more outspoken often than the ministers, and it also includes the European Parliament, but only the Assembly of the Council of Europe, and the ministers who usually are not prepared to say something to one another on issues like this. So I think the important lesson could be for the European Union, if you talk about a monitoring system for the EU, that it should be in the hands of an independent body. Could also be the European Commission or something else. Because ministers and governments are often very hesitant to talk to one another. They have this subsidiarity idea or non-intervention principle that blocks them in talking to one another, unless there is something very extreme. Like if there would be a coup d'etat in Italy, of course Italy would be thrown out of the European Union. But these are not cases. We are not confronted with in practice, fortunately, at least not yet. Anyhow, thank you again very much, Professor Myjer. Now I give the floor to you. You're free to ask questions or make your own statement. There is a microphone somewhere, yeah, in the back. Please mention your name when you ask for the floor. Who's the first? Yeah, over there.
question regarding the division of competences between the European Court of Justice and the European Court of Human Rights. Could you expand a little on this dynamic in the institution?
Okay, dus you mean the courts in Strasbourg and in Luxembourg, yeah.
Well, originally the European Court of Human Rights only is the court for human rights in Europe. And when you look at the very beginning, you had Strasbourg, Council of Europe, that was about democracy, rule of law, human rights. On the other hand, you had the bodies of what is now the European Union, which first had to do with money, with trade, all these kind of things. So there was a clear division in tasks in the beginning. And in the beginning, also Council of Europe members and what is now EU members were practically the same Western European countries. At a certain moment, due to the Maastricht Treaty, I think it was the Maastricht Treaty, there was a lot of other tasks also for the European Union, and was also finally the legal cooperation. In the end, especially since there is also the Charter of Human Rights now part of the Lisbon Treaty, the human rights as such do also count for what has been done, what is done within the European Union. Still, as far as human rights interpretation is concerned, until now, the two courts have clearly said, well, the final answer to at least interpretation of the European Convention of Human Rights is to the Strasbourg Court, to the European Court of Human Rights, because that's the only body dealing with the European Court, with the European Convention of Human Rights. However, what is now happening is that since there is the Charter of Human Rights adopted within the European Union, that the Court of Justice in Luxembourg more and more is confronted with cases where directly the Charter of Human Rights is invoked at the Luxembourg level, and where the Luxembourg Court, because it is about the interpretation of the Charter, indeed could go further, if need, than the European Court of Human Rights. As I said, the European Union is now 28 countries. All 28 are also member of the Council of Europe, and are also member party to the European Convention of Human Rights. But next to the 28, there are in total 47, so 19 others, other European countries, who are at least under the umbrella of the European Convention of Human Rights. So there is well, the task of Luxembourg is mainly about what is being done at the EU level about the interpretation of the EU instruments, which is in a way different from the task of the European Court of Human Rights, which has to do with interpretation, application of the European Convention.
I hope this was a clear answer. Yes, thank you. There was a question over there, please. Bring the microphone over there.
I'm Harry Hammond, Netherlands Helsinki Committee. Two questions, basically. You're talking about, you know, the successes of the European Court of Human Rights, and I agree that in comparison, at least, with what happens at the global level, the UN, which what happens at regional level in other continents, the European system is, an excellent way of dealing with human rights abuses. But you're also saying that the monitoring of human rights violations should be done by a non-political mechanism. In the system that you described, in the monitoring of the implementation of the execution of the judgments is, the task of the Committee of Ministers, which I think, in my humble way of seeing things, is a political body. And you know, in the Macedonia example, for example, will this prime minister be actually brought to justice under the Macedonian system, which I think should be part of the implementation of Macedonia, by Macedonia of the judgment. You know, it should be on the list of demands that the Committee of Ministers should make to the state of Macedonia. Do you see any possibility? So, from my perspective, you know, I think that, you know, even though comparatively speaking, the European system is good in comparison to other continents, you know, objectively speaking, I think a lot of improvements could and should be made. Most of the public discussion in a country like the Netherlands has been in recent years about limiting the power of the court. I think there should be a lot of discussion about strengthening the power of the court and strengthening, in this case, in my example, the power of the independence of the execution oversight. Second point has to do with speed. When I look at a country like Turkey at the moment, you know, I see here a deterioration of human rights situation. You know, all NGO monitoring organizations, you know, indicate quite severe regression in freedom of expression, for example. You know, many more journalists in prisons than ever, highest number in the world. In which way do you think, you know, the European human rights system would be able to deal with this in a more preventive way, rather than concluding in 5 years' time that actually, you know, the convention has been violated by Turkey? Are there ways to strengthen, you know, the operation of the convention in this way?
Well, now we go into the depth. The first question, as far as the execution of judgments is concerned, I still say yes. The court system is a success story, but it is not everything. One of the things, for instance, is the court will only react when there is a complaint. It means that as long as there is no complaint by an individual or by another state, the court will not deal with it. There's no prosecutor, indeed. So that is one of the things which indeed is a weakness of the system. The other thing, the execution of judgments, that was deliberately done when the convention was set up, that at least the last word on execution should be with the Committee of Ministers, and that is a political body. I totally agree. However, also that political body can be monitored and supervised as far as even the speed of execution of court judgments is concerned. I agree. It is deliberately done, and it is in a way a weak system because the execution is done by the diplomats themselves. On the other hand, in the execution, it's sometimes necessary to have also diplomacy involved, and there it has advantages. In the past, even the Netherlands have been on the list for years and years before finally a case got off the list and it was totally executed. There has been a so-called Brighton conference last year. Finally, Brighton comes here. And Brighton conference in April last year was a summit of ministers on the future of the European Convention. And one of the results of the Brighton conference was also to say that at least parts of the execution should be done in a more speedy way. So the Brighton conference itself also acknowledged that something should be done. And I read from the results of the Brighton conference, each state party, and this was adopted again by the ministers, has undertaken to abide by the final judgment of the court in any case to which they are party. So if the court says you should get rid of an automatic loss of voting rights once you're detained, and the court has said it twice or 3 times, then each country, including the country to which I'm referring now, has undertaken the obligation to abide by the final judgment of the court in any case to which they are party. Through its supervision, the Committee of Ministers ensures that proper effect is given to the judgment of the court, including by the implementation of general measures to resolve wider systematic issues. The Committee of Ministers must therefore effectively and fairly consider whether the measures taken by a state party have resolved a violation. The Committee of Ministers should be able to take effective measures in respect of a state party that fails to comply with its obligations under Article 46 of the Convention. And the Committee of Ministers should pay particular attention to violation, disclosing a systemic issue at the national level, and should ensure that state parties quickly and effectively implement pilot judgments. That has been elaborated last year in Brighton, and well, we all know that certain countries also quite openly say, we don't like the judgment and we are not going to execute it. Then the Committee of Ministers, according to what has been written down in the Brighton Declaration, should take a firm stand. That's the first question. The other question on Turkey is of importance, of course. By the way, Turkey is not the number one on at least the list of countries found in violation. But Turkey is also smaller than other countries. This very morning, I read an interview with my former Turkish colleague, Işıl Karakas, who is the judge now, the Turkish judge in the European Court of Human Rights, given in a Turkish newspaper. And what she says in that interview is, Turkish judges should not be afraid to apply human rights standards, and they should finally give up their way of automatically thinking that what the government does is right. And what she says is fantastic. And she says, well, she's very polite, but she almost says, when you read through the lines, the hell. It took the European Court of Human Rights judgments before it was finally allowed in Turkey to mention the word Mr. Öcalan. Because if Öcalan was mentioned before our judgments, then immediately a journal, a newspaper, would be closed down for a couple of weeks, would be heavily fined. Things like that have stopped. The prohibition of using the Kurdish language, which was also something which happened there, has stopped thanks to Strasbourg case law. And I agree, still a lot has to be done in that specific country. But when you look at what my former colleague said to her fellow judges in Turkey in that interview, I think, well, some things can happen now in Turkey which could not happen, say, 20 years ago. So at least there is some improvement.
I think in the case of these journalists in Turkey, most of them are Kurdish journalists who have been put in jail under anti-terrorism laws, which makes it somewhat complicated. Sam Rosemond, here.
No present affiliation. Since we are here the guest of the Montesquieu Institute, when picking up the sheet, I was looking for a trias politica, and I found a deliberative organ and a judicial organ and an executive committee of ministers, and I was wondering who the legislator could be. And the answer might be that is the Committee of Ministers, but since they can only decide by unanimity, and since the court has a large measure of freedom in interpreting general principles by simple majority, I wonder if you could agree that the court has some characteristics of legislator, perhaps even more so than the committee of ministers, and if you don't agree, how can you prevent being open to criticism from the British government or from people like Charlie Baudet?
Is there any time limit?
Yes, 5 minutes.
All right. Montesquieu wouldn't have liked what has been said in Article 32 of the Convention. I read, "The jurisdiction of the court shall extend to all matters concerning the interpretation and application of the Convention and the Protocols." The European Convention of Human Rights, if it would have been drafted by Montesquieu, would have only said the jurisdiction of the court shall extend to all matters concerning the application. But it clearly indicates the court is allowed to interpret. Not to interpret in the way, well, we do what we like, we are now the European gods or whatever. On the contrary. No, but what the court can do is to interpret at least within the framework of the Vienna Convention on the Law of Treaties, where it also is indicated what kind of interpretation methods you are allowed to use when interpreting international conventions. The court is allowed to at least interpret according to these general instruments of interpretation. And it means that the court every now and then will interpret according to present-day conditions. To give an example which is not a, which is a little bit, what is flauw? Flauw.
Weak.
A weak. All right, a weak point. When the convention was drafted, letters were still delivered by pigeons, and now we do it by emails. But it would be ridiculous to say that correspondence only applies to pigeons and not to emails. So of course the court will interpret correspondence according to present-day conditions. So in interpreting that way, the court indeed might interpret in a way which some people would consider as the legislator interpreting new facts. But it's not new. They will always interpret according to the general principles laid down in the Vienna Law of Treaties. That's my point. What, however, happens every now and then, that is that sometimes when there is a particular consensus within Europe, that the court may widen the scope, since a certain issue is now also accepted, or almost everywhere accepted within the Council of Europe. To give a clear example, at a certain moment, it's an old example, at a certain moment the first transsexual came to Strasbourg saying, listen, in my country there is not sufficient legislation. I'm now made from a man to a woman, transferred from a man to a woman, but I still have my passport stating that I'm a man. And now I have to serve a prison sentence, and I have to serve it in a male prison. And I want to serve it in a female prison. Could you please help? And the court first said, sorry, there is no European consensus about something like the rights of transsexuals. So can we then see it as part of the Article 8, the private life issues? No, we can't. And several other attempts were made, and at a certain moment the court said, yes, now within Europe there's so much consensus that now we accept that we widen the scope of private life also to the rights of transsexuals. So things like that have happened. And is that legislating? I doubt. When you look at the needs of transsexuals, then I think the court should have done it earlier. But when you look at the subsidiarity principle, don't do to countries what they haven't decided yet themselves, then you shouldn't do it. So I think the court is rather careful. And as far as what does the court do towards countries or people who seem to be very much opposed to what the court says, let me say again. Looking at, for instance, the United Kingdom. United Kingdom and Netherlands, as far as statistics, are almost the same. 97% of the cases directed against the United Kingdom or against the Netherlands will be declared inadmissible right away. 97%, which is higher than any other country. And of the remaining cases, it might be so that in these cases that the court will find a violation, but then we are only talking about in 1% of all these cases. And what is happening is, indeed, the United Kingdom is a very open country where people like to litigate and where sometimes cases come to Strasbourg which have not come from other countries. And in that respect, sometimes cases against the United Kingdom are leading cases. That may happen. But when you really look at the cases, the United Kingdom is concerned about voting rights for prisoners. And they once tried, in an Italian case, to say, well, could you please change the system? And now they know that, according to Article 46 of the Convention, they should just abide to the final judgment. And now it's up to the Committee of Ministers to do something about it. And as far as Thierry Baudet is concerned, once he knows something about what's really going on, I will answer his question.
Okay, I think it's time to wrap up. It's almost 4:45 Friday afternoon. Time to have a drink in the foyer, so to say. So thank you again very much, Professor Myjer. I think that the question, of course, of Van Rosemont was very relevant about separation of powers. And you could also apply this question to the European Union itself, where we have a court in Luxembourg that is a silent integration power. And that has done a lot where you could say, is this also not legislation? And where we have also a situation where, talking about a committee of ministers, the controllers are also the controlled, or the other way around. And this is, of course, a system that will never work. That's why I really like your expose about the independent mechanisms that we have in the Council of Europe. And I think that would be a good example of how we could develop inside the European Union an independent monitoring mechanism in relation to protection of the rule of law. Thank you again very much, and I thank the audience for being here and taking part in the debate. I want to thank the organizers of